Hey guys, and welcome back to another of my YouTube videos. In this one, I'm going to be teaching you how to prepare for family court, the kind of things that you can expect. And don't forget, if you like this video, please give it a thumbs up and subscribe. For those of you who don't know who I am, I'm the Legal Queen, a family law solicitor practicing in England and Wales, have been for over 20 years now. I thought this video would be helpful for those of you that perhaps find yourself in a situation where you have to go to family court. There are a number of reasons why you might find yourself in family court. It could be that you need to arrange child custody or child contact with the other parent. It might be that you're not in agreement as to how the finances are going to be divided following your divorce. Or it could be that there's an issue with your divorce and the court has listed your matter for a very short hearing to find out a few more details. So what I'm going to do is give you a very brief overview of what to expect if you find yourself in one of those three situations. So let's kick off with divorce. Typically, because we've got the new no-fault system of divorce that came into play in April 2022, we are rarely going to family court anymore with divorce. However, there are the odd times that you might find yourself there. The first example that springs to mind is where we need to make an application to stay proceedings. We might need to stay proceedings where, for example, we do not want to apply for the final part of the divorce because we haven't applied for our financial order, but the other side are pushing for that divorce to be made complete. In that instance, we have to do a separate application and say to the judge, look, we're not ready to be completely divorced yet because we still need to sort out the finances. So could we ask that the court place a stay on proceedings? In other words, just pause the proceedings until we get the finances sorted. When you get to court, it's not anything like what you see on the movies or on the TV. Family court is private court. So what that means is the only people within the courtroom will be the judge, you and your ex. If you decide to bring along legal representatives with you, such as your solicitor or a barrister, obviously they are allowed in the courtroom as well. So there's only a very small number of people within the courtroom. This is very different to, let's say, criminal proceedings where you have the public gallery. So anybody can simply walk in off the street, sit in the gallery and watch what's going on. That doesn't happen in family court. The other thing to note is that family court isn't always held in a courtroom. Again, to make the situation seem less daunting, a lot of courts, when you go into the family court arena, will be like large conference rooms, if you will. So you're actually sat round a large dining table with perhaps the judge at one end and you and your ex sat opposite each other. So again, don't always think it's going to be this huge big courtroom that may make you feel intimidated. They're not all like that. Right, let's move on to the second example I gave of where you might find yourself in family court, and that's for finances. When you put together a financial order following your divorce, it can be agreed upon in one of two ways. We can agree it without ever needing to go to court. So you and your ex know exactly how the finances are going to be divided. Your solicitor, one of your solicitors, will then draft up a financial order and we simply submit it to the court electronically. So we'll upload it using the portal. The judge will read it, and as long as it's fair and reasonable, the judge will make the order and therefore no one needs to attend court. The odd time an order may on the face of it look unfair and unreasonable. For example, we might not be splitting the equity exactly 50-50 because there are reasons as to why we shouldn't. Maybe the parties have agreed that one of them can keep all of the inheritance or one of them can keep all of the pension because the other person is going to keep all of something else that means something to them. Okay? In that case, on occasion, the judge might say, can I just have a short meeting with the parties, literally 10 or 15 minutes, bring them into court, we call that a hearing, so that the parties can explain to the judge why in their view they consider this order to be fair and reasonable. So whilst it's an order that's been agreed upon by consent, in other words, by you and your ex, the court may just want to cross the T's and dot the I's by having a short conversation with you. If you and your partner are not in agreement as to how the finances are going to be divided, then it may be necessary to make a court application. So what that will involve is you actually attending court. Now, in financial proceedings, once you've made your court application, that's what we call them, financial proceedings, there will only ever be 3 hearings, okay? If you and your ex cannot agree at number 1 or number 2, then the court will decide at hearing number 3 as to exactly how those finances are going to be divided. Again, same format as I've already said in the video, not always the big courtroom that you see on TV. Sometimes they're going to be smaller, almost conference room style in appearance. There will be no members of the public in there. It's a very private court. Family court is private. There will be, however, lots of paperwork that you need to prepare. So, for example, and this might be helpful if you want to look up any of these forms, when you want to begin your court application, you're completing a Form A. Once your application's been issued, you'll then have to do a Form E. You're going to have to do a chronology. You're going to have to complete an ES1 and an ES2. And you're also going to have to let the court know of what your mortgage affordability is and particulars of houses. So any properties that you consider to be suitable for you moving forward, whether that be to buy or whether that be to rent. When you've made your financial application, you will be sent a pack by the court. And in that pack, it will have a lot of what I've just said. So don't worry too much about memorising the names of those forms, because the court pack will let you know exactly what the form is called, when you have to fill it in, and at what point you have to submit it to the court and swap it with your opponent, your ex. For those of you that want to have a go at doing this completely on your own, and I get, look, it's difficult for people. Litigation can be expensive, especially if you're instructing solicitors and or barristers. So what I've done is I've put together some courses, and you can find those courses on my website, and it will walk you through a complete financial application. It will take you through what to expect at each of the 3 hearings. I show you exactly how to fill out the paperwork. You'll get to see the Form E's, for example, the ES1s, the ES2s, the chronologies, what those forms look like and how you go about completing them. I'll also talk through what you can expect to find when you actually get to court. So if we look at that now, the first hearing is normally called the first appointment. They're not very long. The court want to establish exactly where the disagreement lies. Why haven't you two agreed? What's missing by way of evidence? Or what questions do you both have that prevent this matter from settling? And it might be that you can't agree on the valuation of a property. So that will be the first bit of homework or direction, as we call it, that the court will give. You both go off and you get valuations for a property. It might be that one of you haven't disclosed all of your bank statements. That'll be another direction or bit of homework. The court will say, right, you're both going to go and provide full disclosure. We want the 12 months for all bank accounts that you've disclosed. We want 12 months of credit cards, for example. When you get those bank statements and credit cards or any other evidence from the other side, you may then have questions that you want to put to them. For example, where did this £2,000 come from? What did you spend that £10,000 on? And of course, if we're asking questions, we need to set a date down to have a reply to those questions. So the first appointment is a bit like gathering a little bit more evidence, setting a timetable as to what's missing, what's going to be produced and when it's going to be produced. And then the court's also going to set down the date for your second hearing. Right, your second hearing, little bit more involved now. It's called a financial dispute resolution, or an FDR. It's typically listed for a little bit longer than the first appointment. Your first appointment generally about an hour. Your second appointment may be an hour and a half, sometimes 2 hours. Now, the court's expecting that all the evidence that you both seek to rely upon is in, and that you've both swapped the same and you've all filed it with the court. And the court will start the session again by saying, right, are we in agreement? And if you both say no, the court's going to want to know why. What is still the sticking points and how do we look to overcome them? What the court will also do at an FDR is give you an indication as to how it's thinking it will settle the case. So it will say, look, if we were able to settle it today, and of course the court can't do that at a second hearing, can do that at the third one, it will say to you, if we were doing it today, this is how we would do it. This is how we would be apportioning the equity in the home. This is who the savings would go to. These are our thoughts on a potential pension share. So it gives the parties food for thought, because it might be that one of you is just so entrenched in your position and they honestly think that, you know what, I'm going to take this all the way to a final hearing because the court's going to believe me. So that indication from the court can sometimes be helpful in moving somebody forward and thinking, you know what, okay, I'm going to concede the pension share, but actually I'll go for a little bit more equity in the property, for example. But again, remember, the court's not going to make any final order at that second hearing unless you are both in agreement with the same. So if there's no agreement reached at the FDR, the court's then going to set it down for your third and final hearing. Final hearing. Now these types of hearings, again, dependent upon the complexities, depending upon all the assets or perhaps debts that are involved, are given a lot more court time. They're usually listed for anywhere between half a day to a day, sometimes 2 days. And the reason for that is that now the court want to hear from you both. They want to hear from you as to what you think your case should be. And of course, the other side are going to be able to cross-examine you and put some questions to you. And then, of course, your opponent, your ex in this case, will also have their opportunity to get on the stand and tell the judge why they think their point of view should be the one that wins. And you'll be able to cross-examine them, or your legal representatives will. So that's why it's given a lot more time. And then typically the court, once it's heard from both of you, once it's heard legal argument from your solicitors or from your barristers, and once it's taken some time to read the papers, it will then hand down that final order. And that order is then not up for debate, because whatever the court decide is the order that will be made. And this is why the majority of financial applications will generally settle at the second one. Always better for you two to decide what that final order should be rather than a judge, because each family is bespoke. So whilst the judge will apply the law, once the law's applied, it may not sort of tick the boxes that both of you need to be ticked. So typically they will settle at the second hearing. But if they don't, you're going to go on to a final hearing. At the end of the day, you're going to get your final order with regard to the finances. Let's move on to children's applications. So this will be another example of where you find yourself in the family court. Let's start with making very clear what the law says in England and Wales about children. It's the children's right to have a relationship with both parents, okay? So if you are a parent of a child or children and you're not being afforded an opportunity to have a relationship with them, whether that be contact, daytime contact, overnight contact, whatever it might be, taking them on holiday, and you have parental responsibility, you can make a children's application. Now, I mentioned parental responsibility. If you don't have parental responsibility, let's say you're a father watching this and you aren't named on the child's birth certificate and you're not married to the mother, that's okay. Unless mother is saying that you're not the biological father, you're still able to submit your application to the court. You're just letting the court know, technically, I don't have parental responsibility and therefore I need permission to make this application, but I am the child's biological father. What the court will do when it gives you your child arrangements order, which is what they're called, it will also give you parental responsibility. So don't worry about that point. Just know that if you are the biological parent of the child, you will be able to make an application to the court, even if you don't have PR, okay? So, what can we ask the court for help with? What kind of orders can we get in terms of children orders? We can get a child arrangements order, and that will set down in writing who the child lives with, and that might be with both of you. We call that a shared care. Or it might be who the child lives with and how much contact they spend with the other parent. It might be what we call a specific issues order. That's where, let's say, two parents can't decide on which school the child should go to. So a specific issues order, the court will then consider evidence, there'll be lots of different hearings, and then the court will decide which school the child shall go to if the parents can't agree. Another type of order is a prohibited steps order, where you want to stop something from happening. Sometimes when parents split up, clearly the relationship isn't great at the time, there can be lots of arguments, and perhaps one of the parents is threatening to remove the children, let's say from school, or to remove the children and not return them to the other parent. What you can do in that instance is apply for what we call a prohibited steps order, an order that stops that parent from removing the children from you without your agreement or without further order of the court. As with any court application, you would submit it online. It's going to attract a court fee, a children's application, of £232. And remember, you're submitting it to the family court nearest to where the child lives, okay? Now, children's applications are very different to financial applications. With the finances, we only have the 3 hearings. Sometimes we finish in 2, as I said, but with children's hearings, it will take as long as it takes, okay? So whilst the court do try to wrap children's hearings up as quickly as they can so that the parents can just get on with the job of co-parenting and the children can have a relationship with both parents, it won't rush it at the same time. One of the first things that the court will do when they receive your children's application is to ask CAFCASS to help them. CAFCASS are social workers, but they work in the court arena. So they'll work with families within litigation. And one of the things that CAFCASS will do is what we call a safeguarding letter. So they'll just put both parents and the children's names through the social services computer, through the police computer, and see what that churns up, just to get some history of the family. Have they been involved with social services before? Do either of the parents have a criminal record? That will all take place prior to your first appointment, okay? CAFCASS, their involvement may be ongoing. So let's say we've got allegations. Allegations maybe of domestic abuse or domestic violence. They might want CAFCASS to maybe do a bit of a detailed or a deeper dive, speak to both the parents, find out what's gone on here. Let's try to establish if we have any genuine welfare concerns in respect of these children. And if we do have genuine welfare concerns, one of the things the court might then do is list it for a fact-find hearing. And what that means, it's almost like a trial within your application. So they'll pause the children's application for a moment, and they'll do this trial to ascertain if the allegations that one parent's making against the other are true. And of course, if the court then find that they are true, and then you pick up with the child arrangements application, it may impact the order that's made by the court because they found in favour of the parent making the allegations. Sometimes the court don't find the allegations to be true and the child arrangements application continues, and then the outcome is a normal child arrangements order with both parents having a relationship with the child. As with the other 2 examples that I talked about, children's court, family court, it's private, so no one's going to be there, only the judge, you, your ex, any legal representatives that you've selected, and maybe the CAFCASS officer. CAFCASS are generally really busy, so they don't always have the opportunity to attend court, but if they are at court, sometimes the judge will ask that they're present to maybe hear directly from CAFCASS, so that CAFCASS can report back, perhaps once they've spoken to mum and dad. But it will always be a private court. Members of the public are not allowed in. With children's applications, there are many hearings, all given different names depending on what they're for. So it may be called a FHEDRA, First Hearing Dispute Resolution Appointment. Bit of a mouthful, I know. You then might just get a standard DRA, Dispute Resolution Appointment. You're going to get a first appointment, which is going to be the very first one. It might be listed for a fact-find hearing. It may be listed for a final hearing. The important thing is just to be aware, really, less aware of what it's called and more aware of the kind of work that you need to do in preparation for that hearing. I hope you enjoyed this video. If you did, remember to like and subscribe, and I look forward to seeing you next Wednesday for another family law video.